All right. Super. And we are live. All right. And here we go. Okay. So cases, we're going to try to do these in a chronological order. Um, as far as earliest to latest or somewhere in between, maybe skip around a little bit. We're going to start with the big boy. Okay. The one that's probably the most important case, and that's Marbury v. Madison. Marbury v. Madison, early U.S. Supreme Court. I have like the fact pattern over here as far as the key facts or the description of the case. And then in the far right-hand column, ultimately how the court rules. And on the left here, the parts of the Constitution that are being examined. So again, Marbury v. Madison, you have a William Marbury who gets appointed by President John Adams. While John Adams is on his way out of office, Thomas Jefferson's the new president. You have the midnight judges, so to speak, and James Madison has been ordered by his new boss, Thomas Jefferson, the president, to not deliver these commissions. He says they're null and void because John Adams is no longer the president. Okay, William Marbury gets super salty about that. He fights it in court. He asks Chief Justice John Marshall to force James Madison to deliver his commission using a writ of mandamus or Damus, excuse me, depending on who you talk to. William Marbury argued that per the Judiciary Act of 1789, that the Supreme Court had the power to force Madison to do this. And so John Marshall, early Supreme Court case, right? This is early 1800s now. 1803 is the year. It's a wild time. And John Marshall is faced with a huge decision, one of the many big decisions that he's going to have to make as the Chief Justice of the Supreme Court. And ultimately, he rules that the court did not have the power to make Madison deliver the commissions. He says that Marbury is, in fact, yes, entitled to the commission, but that the court and the law lack the power to force James Madison to deliver these. And so in doing that, a few important things happen. So this deals with Article 3 of the Constitution. But in making that ruling and saying that this Judiciary Act of 1789 is unconstitutional, John Marshall is going to give the Supreme Court some teeth and establish this power of judicial review. Again, that is the one important power that our Supreme Court, that our court system has, is ruling laws and actions, in this case, Judiciary Act of 1789, to be unconstitutional. Again, power of judicial review is not used anywhere in the Constitution. It is this case, the Marbury v. Madison case from the early 1800s, that's really going to cement the Supreme Court as having some sort of legitimate power in this power of judicial review. So this precedent, this power is established. Excuse me. That's embarrassing. Okay. But Marbury v. Madison is going to establish this very important power of judicial review nonetheless, and it is arguably the most important Supreme Court case in U.S. history. Again, big thing you remember about this one is judicial review and the court's power to rule laws and actions to be unconstitutional. Okay. Questions on Marbury v. Madison. Again, that's the important one. Know that one. That is a required one. Okay. Again, we're going to try to do these in some sort of chronological order. So the next one is another John Marshall case, and that is McCulloch versus Maryland. This is the national bank case, where early U.S. history, a part of the economic plan to try to get debts and things kind of figured out and straightened out, was to create a national bank. The state of Maryland did not agree with that. Again, they felt like the Congress lacked power to create a bank. Okay. And so when this new national bank is chartered in the state of Maryland, they get real upset about it, and they're going to try to close the bank down. They're going to tax the bank at a very, very high rate, and a rate so high that the Bank of the United States simply can't pay the tax. In paying the tax, they would more or less defunct themselves. They would go out of business. And so the state of Maryland's like, well, you got to pay the tax. We're the state. We have the power to tax. We are taxing you. You are a bank. You're a business. Pay the tax or don't. And so the president of the bank, this Mr. McCulloch, he's like, we're not paying. Like we can't. And we're a federal entity. Okay. So we're not paying this. We'll see you in court. And so ultimately, this McCulloch versus Maryland case, again, this is 1820s now. This is going to deal with what powers does the Congress have under the necessary and proper clause or the elastic clause and the legitimacy of the supremacy clause. So ultimately, there's two things being decided in McCulloch versus Maryland. First thing is, does Congress have the power to create a bank? And the second is, can the states tax this federal entity? Okay, so the ruling here is important. It deals with two parts of the Constitution. Okay, but to answer the questions, yes and no. Yes, the government has the power to create the bank. That falls under the necessary and proper clause, or what we call the elastic clause. It's a big one to know. And that, in fact, no, the states do not have the power to tax it because that would interfere with the federal entity, and that would be a clear violation of the supremacy clause. Again, the supremacy clause is the statement in the Constitution that says all laws created by the national government are superior to that of the states. So McCulloch versus Maryland, depending on the part of the case, it could either deal with supremacy, and that is, again, federal supremacy over states in making laws, or if it deals with a lawmaking power, that's necessary and proper. Again, necessary and proper clause, or the elastic clause, however you want to say it, allows Congress to stretch its powers to fulfill its functions. So in the Constitution, Article 1, Section 8, there's statements saying that Congress has the power to print money and coin money, the power to borrow money, the power to tax. They argue that it's kind of what a bank does. So why can't we create a bank? Necessary and proper clause, the bank gets created. So again, early federalism case, it's a big one. Understand that one. Okay. Deals with two different clauses. Understand how they apply here. Any questions on McCulloch? Again, it's another early one. It's another John Marshall case. So it's super important, again, in setting the precedent of national powers in comparison to the states. Okay. Again, we're trying to stay in some sort of chronological order here. Let's see what that would bring us to next. Well, let's touch on our two gerrymandering cases. Okay. So again, gerrymandering is the practice in which congressional districts, again, congressional districts affect the House of Representatives because the House of Representatives representation is based on state population, right? So most members of the House, unless you are a Kelly Armstrong or the representative from Wyoming, okay, or the representative from Vermont, you represent a pocket of the state, right? And we had talked in class at length on those districts being drawn in a way usually to favor a political party, okay? So how do you do that, or what's fair and what's not? Because again, congressional districts are not discussed in the Constitution. It just says that members of the House, or that the seats in the House are based on a state's population, how many seats in the House they receive. Again, doesn't affect the Senate because every state, nailed it, Riker, every state gets two senators. Whether you're North Dakota or California, you get two senators. They represent the entire state. Okay, so Baker v. Carr, early or 19, I guess this would be like 1960s gerrymandering case that deals with the population size of congressional districts. Okay. So ultimately what happens is this involves the fine state of Tennessee. And in this case, the Supreme Court is going to say that Tennessee had a malapportionment or misappropriation of seats based on population, that there was a district in Tennessee that had substantially less people than other districts, and the districts had not been redrawn in so long. And so with this case, the Supreme Court establishes the precedent that districts must be substantially equal in population size, not perfectly equal, but substantially equal. The part of the Constitution that's cited here is the Equal Protection Clause of the 14th Amendment. The other part of this that I would know is this establishes what we call one person, one vote. Okay. In other words, that if you have a district that has substantially less people than that of another district, that their votes would essentially count more or carry a bigger weight. And so Baker v. Carr is the one person, one vote case saying that congressional districts pertaining to the House must be substantially equal in population size. So it's one of the very few regulations that the Supreme Court is going to place on how House districts are drawn, or congressional districts. Okay. Again, 14th Amendment Equal Protection Clause of, that is what's going to apply here. Okay. The other gerrymandering case, so still in the House of Representatives, this is Shaw v. Reno, and this involves the state of North Carolina. So unlike population size, Shaw v. Reno deals with the ethnic makeup of districts. Okay. There was a district in North Carolina, the 12th district, that was drawn, really, it appeared based on race. Okay. It was what you call a majority minority district, meaning that there was a much larger portion of ethnic minorities, in this case, African Americans, living in this district than a different one. Okay. And the 12th district, if you remember, was drawn very funky like. That's usually what happens when you see gerrymandering. And in this case, the Supreme Court says that districts can be drawn based on race, but that they cannot be drawn based solely on race. Race can be a factor, but they can't be drawn based solely on race. The 12th district, as a result of this, doesn't really change. Okay. But it may be slightly enough. But in this case, the Supreme Court establishes the precedent that congressional districts cannot be drawn based solely on race. Race can be a factor. Again, majority minority district, what's going to tend to happen there is ethnic minorities are probably going to tend to vote a certain way than non-ethnic minorities might. They might tend to elect a minority representative, so on and so on. And so some of the folks in North Carolina would have argued that that was a violation of their voting rights. Okay. In this case, the Supreme Court says, yes, it is. Majority minority districts are fine, but districts cannot be drawn based solely on race, which again, might be a hard thing to prove in court. But as a result of the Shaw v. Reno case, again, dealing with gerrymandering and race, Supreme Court says that race cannot be the sole factor as to why away districts are drawn. Okay. Questions on those two. Again, both of these are, again, give it a little subject here. Both of these are gerrymandering cases dealing with how congressional districts are drawn. Okay. Questions on Baker v. Carr or Shaw v. Reno? No. All right. Excellent. Okay. We're going to go in then to some First Amendment cases. We'll come back to Roe v. Wade at the end. Okay. Because Roe v. Wade is technically no longer a required case. But again, I don't know. I don't really like the way the College Board has gone about what they want you to know about that. So we'll go back and we're going to do some First Amendment cases. So we have two cases that deal with the freedom of religion. Okay. Engel versus Vitale and Wisconsin v. Yoder. Again, there's two parts to the freedom of religion, or two clauses that you have to know. Those are the Establishment Clause and the Free Exercise Clause. Again, Establishment Clause prevents the government from endorsing a religion. Free Exercise Clause prevents the government from people from practicing their religion as they see fit, within some limitations, right? Like human sacrifice is probably where they draw the line there. Okay. Can't do that. But the two cases to be aware of, first one is Engel. And so Engel is the Establishment Clause case. In this case, that is where the students in New York were asked to stand every morning and recite a prayer, mention God. Okay, the Engel family is going to fight this, saying that, hey, this is the government endorsing Christianity. Okay. The school is a part of the government. The people who work for the school are, so to speak, public agents. And in the school, even asking students to voluntarily recite this, that would be a violation of, you guessed it, their Establishment Clause. So that, in fact, is the government endorsing a religion. And that is no bueno. That's a violation of this. Again, does anybody remember the name of the test that gets established to determine whether or not schools are breaking the Establishment Clause? Does not come out of Engel. The test. It's named after a fruit, a citrus fruit. Anybody? It's yellow. No, Riker, it's not a banana. Get that out of your head. What's it called? I got to chat. My mic won't work. Sorry. It's the lemon test. Oh, thank you, Kyla. Yeah, Kyla's having issues with her mic. It's the lemon test. Okay. And that comes from a different case. The lemon test, though, is something that you're asked to know as a part of Unit 3. The actual case, Lemon versus Kurtzman, you are not required to know the facts of that. But the lemon test is something that you should know. Again, lemon test is what determines whether or not a school specifically or the government is breaking the establishment clause. Okay. Other case is Wisconsin v. Yoder, or as one famous Emma Space Lee called it, the Amish school children case. This is the free exercise clause one. Okay. So again, pertaining to freedom of religion and your freedom to exercise the religion as you see fit. In Wisconsin v. Yoder, the Yoder family wanted to pull their children out of school at the age of 14. Wisconsin had a state law saying, hey, you got to be 16 to drop out. Yoder family says, hey, but we're Amish. It's the part of our religious beliefs. At 14, in our eyes, education for our male students is over. They need to go back to the community and work on the farm or being carpenters or whatever. State of Wisconsin says, okay, neat. You can't pull your kids out of school. Goes to the Supreme Court, where the Supreme Court actually is going to rule in favor of the Yoders. And they say, hey, actually, that is free exercise. They want to pull their kids out at 14. You have to let them, okay? Because that is a legit freedom, or how they're going to exercise their Amish faith is having to do with education, okay? So again, First Amendment case dealing with religion. Again, First Amendment also includes speech and press, and we'll talk about both of those here in a second as well. Any questions on those two? Again, two freedom of religion cases. Anybody? No? Okay, moving on. More First Amendment then. More First Amendment. Next one is the Tinker case, okay? Next one is the Tinker case. Again, the Tinker family, very politically active. And this deals with the freedom of expression, specifically political speech in schools. The Tinker kids wore armbands to school, right? If you remember what they looked like, they were black armbands, had like the no smoking sign, but said Vietnam. They also had a peace sign on them, I believe. Okay. And so not something that we would say would cause a significant disruption of learning, right? There is no expletive. There is no insults being made at any one person or entity. It's just these students expressing that they don't feel the United States being involved in the Vietnam War is the right thing, right? It's political speech at its finest. And the school principal more or less told these children that, hey, by the way, if you wear said armbands to school, you will be suspended. They wear the armbands, they get suspended. Tinker family goes after the Tinker school district, or the Tinker family goes after the Des Moines school district, and the Supreme Court is going to rule in favor of the Tinkers, saying that, yes, these students very much enjoy a political free speech while they're in school, quote, that students do not shed their freedom of expression at the schoolhouse gate, and that these armbands were not something that would cause a disruption in the learning process. Now, at the same token, in this same case, the Supreme Court says that schools do have a right to prevent students from wearing things that might be political in nature if they cause a significant disruption to learning, right? The case in point that I talked about is if a student wore a shirt with an expletive to school, aimed at a politician of sorts, okay, whoever that might be. At that point, the school could say, nope, you can't wear that. That's inappropriate. And students, you wouldn't really have a leg to stand on because of the nature of the t-shirt and the student handbook. Okay. But in this case, Supreme Court says, hey, students do not shed their political free speech at the schoolhouse gate. The armbands are protected speech. The students want to wear their no Vietnam armbands. You can't stop them. Okay. So that's another freedom of expression case, specifically in schools dealing with political speech. Okay. Our last two First Amendment cases here, New York Times. This is a freedom of the press case. This involves the Pentagon Papers, right? The Pentagon Papers were classified documents that get leaked to the New York Times, among other news outlets. And the Pentagon Papers more or less were these classified documents. They get leaked. They more or less showed or proved that the United States had been misleading the public on U.S. involvement in Vietnam, that there were some things there that happened that were bad. The war effort might not be going as what people are being made out to believe. Okay. And so the New York Times, they get these, they know they're classified, and they go to their lawyers and they say, well, what can we do? Can we publish these? Like as a media, okay, as a media entity, our job is to share information with the citizens. And so when President Nixon finds out that the New York Times and the Washington Post, that they want to publish these papers for people to see them, he asks for the blockage, okay, the blockage of the publication of said paper, saying, nope, that creates a national security threat, prior restraint. Okay, that's the thing that comes up here, is Nixon asks for prior restraint that would prevent these media outlets from publishing said papers. Okay, the Supreme Court says, we have a heavy presumption against prior restraint. Okay, and the big reason for that is because the press doesn't serve the governed, it serves the governors. Or excuse me, I got that dyslexic moment. The press serves the governed, the people, not the governors. In other words, the job of the press is to educate, to inform, and the blockage of these papers would be a violation of the freedom of press of these media outlets. Pentagon papers are allowed to be published, kind of paves the way again, upholding that freedom of the press. Okay. All right. Last First Amendment case. This one deals with, well, I guess second to last First Amendment case. We have one more, is Schenck. Charles Schenck again. This is World War I era. World War I era. Mr. Schenck starts circulating literature, pamphlets that encourage young men to avoid being drafted, okay, saying that there was a violation of constitutional rights and that the government cannot force young men to sign up for the draft. Okay, again, also important to note that Mr. Schenck was a socialist, which again, that is not a crime. Okay, but wartime United States, the Espionage and Sedition Act had been passed. Espionage and Sedition Act had been passed that placed a great limitation on what could be said about the government and the war effort during World War I. And so Mr. Schenck, when he starts circulating these pamphlets encouraging young men to dodge the draft, avoid being drafted, U.S. government goes after him. He gets charged with a crime under this Espionage and Sedition Act. He fights it saying, hey, free speech, political expression, hello. And the Supreme Court says, yeah, not really. Clear and present danger that what is being circulated here interferes with the war effort. It could create, it could create a clear and present danger, so to speak, with the United States and our security. This is not protected speech. I guess another quote that comes out of this is, if you go into a crowded theater and yell fire, what do you think the reaction will be? It would create panic. It would create danger. This is not protected speech. Okay, later it gets overturned with the Brandenburg case. Brandenburg is not required, but Schenck is. Questions on those ones? We'll come back to Lopez here in a second. I know you're excited for Lopez and the never-ending confusion that it brings. All right, last First Amendment case then is Citizens United. Again, this is a Unit 5 one, and we'll talk more about this one at a different date. But Citizens United deals with, again, political free speech and corporations, okay? Big money organizations. Again, you had the Citizens United, this organization that's very conservative in nature. They wanted to publish or have a movie played that would have thrown some shade at Hillary Clinton leading up to the election in 2008. They are told they can't do it. That some of these contributions that are being made, even though they're not going directly to the campaign, that they're not okay. Citizens United challenges that and says, hey, as an organization, we enjoy free speech. Okay, we are an organization where we might be a corporation, an interest group, whatever you want to call us, but political donations are free speech. And so Citizens United is the case against the Federal Election Commission, in which they are going to challenge donations being given not directly to campaigns. There's still a limit on that, okay? What can be given directly to a politician for their campaign. But what Citizens United is going to establish is this very slippery slope and the creation of super PACs, okay? That donations are a form of political speech, and Citizens United is going to pave the way for super PACs or political action committees to start giving unlimited amounts of money as long as they don't go directly to a campaign. So that's why you have like a Citizens United or something along those lines. And they argue that their campaign or their how they spend their money politically is a form of free speech. Split decision, the Supreme Court agrees with them. So again, this case deals with specifically with political speech and expression, but specifically donations as political speech. Now, if you get the question on an FRQ on your test, like compare Citizens United to something else involving campaign donations, they would say, okay, what part of the Constitution? Identify the part of the Constitution that these cases deal with. You would say First Amendment, freedom of political speech, period. Okay. That's how you would word that. You would not say donations, but understanding that the donation in itself here is the speech that is in question, how that money is being spent. Okay, questions on Citizens United. So what does this do? Paves the way for big time organizations, big money organizations, i.e. Citizens United, to more or less start giving wildly as long as they're as a super PAC and they're not giving this money directly to somebody's campaign. Okay, so that's Citizens United. It's another First Amendment case dealing with political contributions. Okay, covers those ones. We'll come back to Brown. Let's touch on Roe v. Wade just because we're here. Again, Roe v. Wade is no longer a required one, but what it creates is this right to privacy. That again, this case gets overturned with the Jackson versus Dobbs case. I would still be aware of it. Now, again, the College Board has been very consistent in saying that you will not be asked about this in an FRQ, that it's not a required case, but that the precedents like this right to privacy and where they come from can technically be asked about, okay, based on the amendments. So again, Roe v. Wade is a civil liberties case. It deals with, because it's civil liberties, it deals with due process clause of the 14th Amendment. The Supreme Court cites the First, Fourth, and Ninth Amendments as what implies people having a right to privacy, in this case, how they handle a pregnancy within the first trimester. Again, this case gets overturned with Jackson v. Dobbs. That was just this past summer. And now states have the power to determine what their regulations or laws would be pertaining to abortion. Okay. All right. Moving on from that. Last couple here, cooking with gas. Okay. We got 3 left and then we are all done. Maybe we'll get out of here a little early tonight. So McDonald v. Chicago. This is a Second Amendment case, deals with gun ownership and how guns are stored and that type of thing. So city of Chicago, again, had made a law basically that banned handgun sales. Okay, that's more or less kind of what had happened in the city. Chicago, again, had been known for gun violence. And so late 2000 teens, right? I think it was 2010 case, 2008 case, whatever. So somewhat recently, within the past decade or so. Excuse me. City of Chicago had passed this law. Mr. McDonald's going to challenge it. Okay, now again, there was some similar precedent that had already been established for this case and how the Supreme Court was going to rule, because that goes back to the DC versus Heller case. Again, DC, though, the District of Columbia is not a state. And so even though somebody, conservative Second Amendment person might argue, hey, that's selective incorporation. Again, selective incorporation is the process through which we apply the Bill of Rights back to the states. They might argue, well, DC, close enough to a state, but it's not a state. Okay, Chicago is a city within the state of Illinois, and the McDonald versus Chicago case is going to selectively incorporate the Second Amendment, saying that the Chicago handgun ban and laws preventing handgun ownership or purchasing were unconstitutional. Okay, but again, DC versus Heller, it's very similar, but this does not imply the Second Amendment because, again, remember, DC, well, District of Columbia is a district, it's not a state. Okay, but it's one of the selective incorporation cases. Brown v. Board. This is segregation, right? This is going to overturn the Plessy versus Ferguson precedent, saying that actually separate is not equal. This deals with the segregation of schools. Unanimous decision. The Supreme Court says, you know what? You're right. Okay. Now, again, this is a civil rights case. So when we start talking about civil rights, we're looking at the equal protection clause of the 14th Amendment. Anything that's a civil liberty dealing with like the Bill of Rights, that's always going to be a due process matter. Okay. But Brown v. Board civil rights case deals with equal protection. Okay. Oh boy, we have 2 more here. We have to do Gideon. So where did Gideon go? Okay, we'll come back to Gideon. U.S. v. Lopez. It deals with the commerce clause. Is bringing a gun to school commerce? Supreme Court says no. You have the young man in question, and Antonio Lopez brings a gun to school to sell it, gets caught. Prior to that, the Congress had passed a national law called the GFSA, or the Gun-Free School Zone Act of America. And more or less, they said that the federal government had the power to ban guns on school property because it would interfere with commerce. Okay. Lopez brings the gun to school, even though everybody and their mother would agree that's foolish. That's a bad life choice. He argues that, hey, the GFSA, Congress didn't have the power to make that law in the first place. Congress says commerce, right? There's guns in school that could cause, that could interfere with the trade between states. Supreme Court says, you know what, that's actually a reach, and that this case does not involve commerce. Therefore, GFSA is not an example of states. What this allows, paves the way for states to do, and local school districts, is to start passing their own laws to prevent handguns and guns from coming to school. Okay, again, guns in school, not commerce. Can states pass their own laws? Absolutely. But this case is going to start to limit the scope of the commerce clause, okay, or trade between the states, interstate commerce. Okay, bringing guns to school is not an example. Again, if you see this, and again, I've been betting on this for years, that they're going to try to use this on the FRQ to trick you guys. U.S. v. Lopez is not a Second Amendment case. It involves the commerce clause. Okay, questions on that? All right, cooking with gas. And last one here for the now. Gideon versus Wainwright. The phrase to remember: a Florida man walks into a bar, right? That's literally the name of the game here. Clarence Gideon walks into a bar after closing time, breaks in, steals a couple bottles of wine and some change out of a pool machine or a jukebox or whatever, gets caught. Okay. He's put in jail. He asks for an attorney. The state of Florida says, no, this is not a capital case. This does not involve the death penalty. Okay. In the state of Florida, we only provide court-appointed attorneys for capital cases. This is burglarizing. Okay. We're not giving you an attorney. Gideon, who again had like an 8th grade education or something along those lines, says, well, I don't think that's right. Gets it all the way to the Supreme Court. The Supreme Court says, yes, sir. Yes, you have the right to court-appointed counsel, right? You have the right to a defense. Okay. The 6th Amendment right to counsel. It's a big deal. Again, this is another selective incorporation case. And it's going to apply. There it is. And it's going to apply this 6th Amendment, the right of counsel, back to the states. Again, how do we do that? We use the due process clause of the 14th Amendment and say, hey, states, nope. Mr. Gideon, even though he's made a bad life choice, he has the right to an attorney. Got to appoint one for him if he can't afford it. Gideon v. Wainwright, Florida man walks into a bar. Okay. Oh, man, we are cooking. Okay. The last 2 cases that I have here, they are not required. Okay. But I picked and that's why I listed them as non-required, but still good to know. That's Miranda v. Arizona and Mapp v. Ohio. Again, Miranda versus Arizona involves the 5th Amendment and specifically the right to not self-incriminate. Again, Ernesto Miranda gets accused of like kidnapping and some other things. He ends up saying, yeah, I did it. But he had not been informed of his right to remain silent. Spilt the beans. Supreme Court said, hey, he didn't know that he had that right. So now if people are going to get questioned, interrogated, whatever, police, you need to Mirandarize them, right? So it establishes what's called the Miranda rule. Okay, when a person is being questioned, they have to be read their Mirandas. Now, if you get pulled over for speeding, you do not have to be Mirandaed. Okay, you don't have to. There's probable cause. The cop saw it happen. There's no need for a Miranda. Okay, but if you get brought in for questioning, say, hey, I'm done talking. I don't want to say anything else. They cannot use your silence as guilt. Okay, you have the right against self-incrimination. Okay, so that's Miranda. The big thing that comes out of this is this Miranda rule and in being informed of those rights prior to questioning. Okay. The last one, again, it's not required, but the rule itself is Matt v. Ohio establishes what is called the exclusionary rule. Again, this pertains to the Fourth Amendment and unreasonable searches. Again, a Dallery map in Ohio. They suspected that there was a bombing suspect in her house. They go in without a warrant or a fake warrant. They don't find him. They start looking around her house. They find some contraband, like, pornography or whatever it was. And they charge her with a crime under Ohio law. And she's like, well, they didn't have the right to be here in the first place. This evidence that they found cannot be used against me because it was obtained unreasonably. And the court agreed with her. They said, hey, any evidence that's obtained unreasonably, illegally, cannot be used against you in court. And it establishes what is called the exclusionary rule. So again, these two, not required, but the rules are required. You have to know what Miranda rule is and the exclusionary rule. Okay, I'm going to stop the share. And I'm going to stop the recording if I can figure that out.